when you buy land, what you really buy is a right or interest in the land. And what transfers the interest or right in the land from you, the seller, to the buyer is an indenture. It could be a lease, a sublease, assignment, and what have you, or other forms of instruments that are capable of transferring the land. Now, it is a basic rule of law that when it comes to transfer of interest in landed property or land, you cannot do so by an oral agreement. But there is an exception by which you can have an oral agreement and you would have a valid contract enforceable in law for the transfer of interest in land. And I discussed that with you in this video. I am Godwin Selassie Dakpo, and this is Make It Legal. Make it legal. As a basic rule, the transfer of interest in land must be evidenced by writing. In other words, there should be a written instrument which would evidence a transfer of interest in the land from one person who may be a seller or vendor to a purchaser or buyer. If there is no instrument or written document evidencing such a transaction, the law will not enforce it. Now, what it means is that it is possible for your contract or agreement which you have had with someone for the transfer of interest in land to not be enforceable. And by now you know already that the law requires that when it comes to any instrument that is capable of transferring the interest from one person to another, it should be prepared by a legal practitioner. Only lawyers are persons who are qualified to prepare an instrument or a document that can convey a land from one person to the other. Commissioners of oath are not qualified. Other persons, auditors, engineers, experienced people who work in a courtroom are not qualified to do so. By the law, it is only a licensed legal practitioner who is qualified to do so. That is why whenever it is prepared, you see the lawyer will stamp it. If it is stamped by that lawyer, it means that he is the one who prepares it or supervises its preparation. So without any doubt, you need to have it at the back of your mind that the preparation of the document that transfers the interest is to be done by the lawyer, by the law. That is important. What are the exceptions to the rule that all transactions affecting land must be in writing? So number one, it must be evidence by writing or evidence in writing, and it must also be signed by the person against whom it will be enforced. Usually the seller, the one who is selling it or who is transferring it to the transferee, must always sign that particular written document if it will bind him, or if you, the one who is receiving it, the transferee, can enforce it against him, you, the transferor, must sign it. So if it is signed by you and the other side has not signed it, the one who has not signed it can actually enforce it against you because you have signed it, that I am willing to transfer my interest in the land to you, the buyer. That is very important. So it must first be evidence in writing. There must be a written document which can be produced to show that yes, this land has been transferred from this person to that person, and the details are all outlined in the contract. That is number one. The second thing is that it must be signed by the person against whom it will be enforced. In most instances, the vendor or the seller, it must be signed by such a person, or his authorized agent might sign so. Now, before the agent will sign, they must also be authorized in writing. In other words, you don't just tell a person that Kofi Mensah, go to Amma and buy land for me with word of mouth. No, you don't do that. You must give him a written instrument or a written document authorizing him to go and buy land or sell it on your behalf. So when he sells it or he buys it, he can now sign on your behalf. When he signs it and it's in writing, it is enforceable against you who sent him to go and buy it or sell it on your behalf. That is very important, and it's good to know that as a very first rule of buying land in Ghana, you must ensure that there is a written document that evidences the transaction, and that written document must be signed by the seller or the vendor. Very important. Now, this basic rule has a lot of exceptions, and the Land Act of 2020 at 1036 has enumerated a lot of exceptions that, qualify as exemption to the application of this rule. In other words, when these rules are in place or these exceptions are in place, the requirement that all contract for sale of land must be in writing need not apply. Okay, and I'll share that with you briefly. The first one is that the transfer is pursuant to a court order or judgment. Yes. So if the court orders that you are the owner of the property by reason of that judgment of the court, you don't need to have another written document to show you are the owner. The judgment in itself is an evidence of your right or your ownership rights of the property. So that is the very first exception. So that one, you realize that there is no separate contract for sale of the land. It's just the written judgment, which is also in writing, by the way. So that one gives you a right to be the owner and enforce that right without having a separate written document evidencing the transaction, without having even another person signing it. Just a judge signs it. That is a judgment of the court and you are the owner. It's sufficient to ground your ownership rights. It's sufficient to confirm that you are the true owner of the property. And by that judgment, which confirms your ownership, you can also transfer it to another party or person who is willing to buy it from you. Now you will do an instrument or indenture to transfer to that other person. Remember, it must be prepared by a lawyer. The second exception is where the transfer is pursuant to a will or is by intestacy. If someone dies and left behind a will, and in the will he says that he will give you his land or his landed property, that transfer is effective and enforceable, even though there is no other written document like an indenture between the deceased person and you who is receiving from him, the beneficiary. The only written instrument there is the will, which is not an instrument to transfer interest in land per se, but without having some other instrument, the law will say that you have a right to enforce your ownership interest in that land that was given to you by the will. Now, if the person dies and left behind no will, then a P&C law will apply. And whatever you are entitled to under the P&C law, if it is a landed property, we don't need to have a separate indenture to be between you and the one who is giving it to you, not the deceased person. No, we don't need to have that. The mere indication by the law that you are always supposed to receive it when this person died, whether you are the surviving spouse or the child or the parents, and you qualify to inherit from the person who died, it is sufficient that you are the one who qualifies to receive it. You don't need to do an indenture between the dead person and you who is alive before it to be valid. No other written instrument is required except the one that is stipulated pursuant to the P&C law. The third exception I want you to know about is when you are leasing or renting a property for a period which is less than 3 years or not exceeding 3 years. If you are buying a house or you are renting for a short stay and it's only for a period of 3 years, then obviously you don't need to have a written contract. That is where you can rent a house for 3 years or 2 years without a written contract. And the law will say that 2-year transfer of interest to you is still valid. It's still enforceable. That is important. That is the next exception. The last exception I want to share with you in this video is where you have an oral contract for the sale of the property or for the transfer of interest in the property and it's still enforceable, even though there is no written document. That is when it is an oral customary grant. A grant made pursuant to customs or customary rules. So the transactions that happens pursuant to a custom or traditional practice, and it is not in writing, but it is witnessed by people, and we gave some consideration. It could be money or some sort of a kind consideration for it. Is valid and enforceable, even though it is not in writing. That is important to know. So these are some of the exceptions that you need to know about when you are buying a land. When these exceptions are there, you need to have it in writing. It can be orally made and transferred from the seller or the owner to you, the new owner. And that is important to know. If you enjoyed this video, please give us a like and click on the subscription button. Also, subscribe to the channel. And as always, we love to hear from you in the comment section. So drop a comment and let us know what you think. I am Godwin Selassie Dapo, and this is Make It Legal. Make it legal.